Welcome to students.Com, a learning portal for company secretary students. Presentation on the interpretation of statutes. Part 2. In the Part 1, we discussed some basic aspects of the interpretation of statute. We also discussed certain important rules of interpretation. In this part also, we would discuss some more rules. Then, we would discuss the presumptions. So, first we start with some more rules of interpretation. The first one is expressio unis est, exclusion ulterius. This rule means that the expressed mention of one thing implies the exclusion of others. This rule is not such an important rule for the purpose of interpretation. This rule is merely an aid to interpret the law, therefore should be used with a caution. The rule works on the simple presumption that if one thing is expressly included, that express inclusion would imply that others are excluded. For example, if some provision is expressly applicable on public companies, we understand that the private companies are excluded. But such exclusion may be by mistake, or by an accident. In that scenario, application of this rule may divert from the correct interpretation. So, one needs to be careful to apply this rule. The next rule is Seeta Associates. The meaning of this Latin maxim is it is known by its associates. In general life also, we follow this principle. If we have to judge some person, we also try to see who he friends with. The similar principle could be applied with the words and their meanings, while making interpretations. As per this rule, interpretation of doubtful words may be determined with reference of the associated words in that statute. Although the rule ejusdem generis also talks about similar principle, but its scope is limited to the general word following the specific word. Comparatively, rule of Seeta Associates would have a wider impact. It would consider all prefixed, suffixed or other words used in the language. This is not a sound principle of interpretation. If the language of statute is clear, then there is no scope to apply this rule. The next is Contemporanea, expositio, est optima et fortissima in lege, is another Latin maxim to provide for rule of interpretation. Before we discuss this, let us have some background. The language, words and their meanings keep changing over a period of time. Meaning of those words would change with time. Such improvisation may not happen in 5 or 10 years, but would definitely happen in 25 to 30 years. This Latin maxim emphasizes that the best way to reach at the correct interpretation is to read that statute as it would have been read when such statute was made. If some act or statute was enacted years back, then the meanings of the words used in that statute should be understood as those words used to be read or interpreted at the time of making that statute. The literal meaning of this maxim is that the best way to give the meaning to a document or proposition of a law is to read it as it would have been read when it was made. Even if there has been a change or alternation in the meaning of those words, in the course of time, the words will be construed to bear the same meaning as they had when the statute was made by the Parliament. In India, certain statutes are more than a century old. For example, Indian Penal Code or Indian Stamp Act 1899 are old statutes in India. It is most likely that some of the words used in those statutes have changed their meaning with the course of time. Therefore, if there is a doubt on the meaning of some of the word, we should take the century-old meaning. But this rule could be applicable only if there is a doubt about the interpretation. In the event, plain English meaning is sufficient for having the correct interpretation, there is no need to apply this rule. However, in case this rule is applied, but the meaning still seems incorrect, then it's a likely case that the wrong meaning has been prevailing for many years. In that case, it is immaterial to use this rule for interpretation. And the court will have to give a correct meaning to that statute. However, the courts will not try to correct the meaning if the title of the property is getting affected, or if daily business transactions have taken place with that wrong interpretation. The next is strict construction. Principally, while making the strict interpretation, we do not read anything extra in the language of the statute. As per this rule, if the situation of given case is fitting exactly within the language of statute, we apply the same. And if the situation is even slightly different, we do not apply. The basic example of the strict interpretation is criminal law. Under the criminal law, until the accused is found guilty strictly as per the provisions of law, no punishment could be imposed. For instance, criminal law provides punishment for causing wound or injury by cutting or stabbing with some sharp external instrument. So, a knife or a sword would be external instruments. A sharp metal object could also be an external instrument. But someone's teeth are not external object. Therefore, a wound or injury caused merely by biting through teeth will not be a criminal act, although such biting might have caused a severe wound or injury. Theoretically speaking, strict construction of a statute is a construction which denies or rejects to expand the law by implications or by equitable consideration, and limits or restrains the applicability of law to the cases which are clearly and strictly within the language of statute, as well as within its spirit or reason. Means under the strict interpretation, one cannot extend or expand the interpretation by including the implied meaning, or on equitable grounds, or we say, on fair and reasonable grounds. As per Wilberforce on statute law, under strict interpretation, the act or statute are not to be regarded as including anything which is not within their letter, as well as their spirit, and which is not clearly and intelligibly described in a very word of statute, as well as manifestly intended. So, for strict interpretation, please do not include anything which is not in the written language of the statute, and which is not in the spirit of the statute, and which is not manifestly or apparently intended by the Parliament while making that statute. Now we discuss the liberal construction. In the liberal construction, we have the liberty to expand the meaning of their written language, if such expansion is required, to reach towards the real intention of the legislation. In other words, we say, for advancement of the remedy, that can be done consistently with any construction of the statute. So, the liberal construction is absolutely opposite to strict construction. It expands the meaning of the statute to cover the cases which could be within the spirit or reason of law. The rule of liberal construction is mostly used in case of labor or welfare laws. They are beneficial legislations, and just because of some unclear language in the law, the person should not be deprived for his equitable benefits. Here we take the route of beneficial construction, while interpreting the law. Now, we discuss the presumptions and their impact over interpretation of statute. Presumption means an assumption that is taken as fact. For example, X has been convicted many times previously in the offense of theft. Now, he is again accused for some incident of theft, but there are only circumstantial evidences against him. Judge may validly presume that X is involved in this case also because he has a past record. But this is the example of factual presumption, because it is relating to a fact. Under interpretation of statute, we need to deal with the legal presumption. Let's take another example. As per Article 13 of the Indian Constitution, no Indian law can withdraw or take away the fundamental rights given to the persons in India. So, while making the interpretation of any law, the first presumption to be made is that this particular law cannot conflict or take away the fundamental rights. Means, if there are two choices of interpretation of same law, and one of those interpretations is contrary to the provisions of fundamental rights, judge definitely cannot take that interpretation. This was the example of legal presumption. Now, we discuss certain presumptions one by one. The first is that the words in a statute are used precisely and not loosely. Means, legislature never uses any words or language loosely in the statute. Even a single word in the law should be given its exact meaning. Second is the vested rights. Vested rights means rights held by some person. For example, an owner of a property would have the vested ownership rights. As per this presumption, if a person possessed some rights immediately before the law was passed, those rights cannot be taken away without the express words or necessary implications, or without compensation. Means, the legislature definitely has the powers to take away pre-existing rights by making new law. But, as per the presumption, for taking away those rights, there should be either an express provision in the law, or necessary implication, such as some significant reasons for taking away those rights, or rights are taken away against compensation. Therefore, if some interpretation is resulting in the withdrawal of pre-existing rights without any of those conditions, then it could be presumed that such interpretation is not correct. The third is mens rea. Mens rea is a Latin phrase which means guilty mind is required for a criminal act. It's one of the prominent presumption while interpreting the criminal law, that the accused should not be liable for penalty unless there was a guilt mind. But there are enough exceptions to this presumption. The fourth is that the state is not affected by the statute unless it is expressly mentioned as being so affected. So, the basic presumption is the state is out of the preview of law unless expressly covered. The fifth is that the statute is not intended to be consistent with the principles of international law. Means, presumption is, the statutes can be inconsistent with the international laws. As we know that all the countries are different, their law-making authorities are different. Every country maintains its sovereignty independently. There is no supreme law-making authority at international level. Whatever international laws are applicable are only under some bilateral or multilateral agreements. Therefore, the presumption is that the domestic law is not required to be consistent with the international law. Domestic laws can very well deviate or differentiate with the international law. The sixth is that the legislature knows the state of law. This is another presumption, that the law-making authority is aware about all the laws prevailing in the state. The seventh is that the legislature does not make any alteration in the existing law unless by express enactment. If legislature wanted to make an alteration or amendment in any written law, such alteration shall be made only through another piece of written law. There is no implied way to make alterations in any existing laws. 8th, that the legislature knows the practice of the executive and judiciary. As we know that there are three independent elements of nation's administration: legislature, which makes law; executive, which executes various administrative tasks. This includes all the ministers and government employees. The third is judiciary, which includes all courts. Executive and judiciary play a vital role in implementation of laws. And the executive and judiciary have their own processes and procedures for this purpose. And the presumption is that the legislature is aware about the processes followed by each element, and accordingly the law shall be made. 9th, legislature confers powers necessary to carry out the duties imposed by it. This is another presumption. If legislature has made a law, it has granted necessary powers to carry out the duties. For example, if the police is duty-bound to conduct the investigation of any crime, the necessary powers to search have been delegated to the police to discharge those duties. 10th, that the legislature does not make mistake. It's the basic presumption that the law has been made after thorough background work on the subject matter. Therefore, it is unlikely that legislature has done any mistakes while making the law. However, this is just a presumption, and judge could change the stand if required so. Now 11th, the law compels no man to do that which is futile or fruitless. Means, law cannot ask someone to do something for free. If one of the interpretations suggests that some person will have to do something futile or fruitless, that interpretation cannot be taken. Then 12th, the legal fiction. First, let's understand what is legal fiction with an example. The concept of a company is a legal fiction. As we know that a company is an artificially created person in law. For material world, it's a fictional character. For legal purpose, this fictional person is regarded as good as a natural person in terms of holding property or creating obligations. In real life, existence of a company is untrue. But, for dealing with a legal question, it is safely assumed that the company exists in this world, and many other fictional facts are also assumed, which are required for a company to operate. So, legal fiction is something which is actually untrue. But, the same will not be denied or rejected if some difficulty may be overcome with that assumption, and justice could be secured. Additionally, it's the well-settled rule that, while interpreting the scope of a legal fiction, it would be proper, and even necessary, to assume all those facts on which such fiction can operate. 13th, the delegation of power takes with it the duties. There is a dialogue of one of the prominent Hollywood movie. Great power comes with great responsibility. This presumption also works on the same principle. For example, if police machinery is having various powers, they also have various responsibilities. Similarly, it is also presumed, if a responsibility is cast on someone, he also has the interconnected powers. If there are multiple interpretations possible on the powers granted to someone, this presumption could help to reach at a correct interpretation. Now 14th and last. The doctrine of natural justice. It's one of the most important rules of legal system. If there is a confusion over some interpretation about the powers granted to someone by legislature, one of the presumptions shall be that such powers must be exercised in fair